Hi, I'm Dan Kotin, President of the Chicago Bar Association. Welcome to Justice and Law Weekly. As everyone knows, November 8th is Election Day, and much of the attention has been spent on focusing on this crazy presidential election, and other hotly contested state and federal races are happening too. But on November 8th, we also have a judicial election in Illinois. 35 Appellate and Circuit Court of Cook County judicial seats will be elected, and 58 sitting judges are on the ballot seeking retention. Our program today will focus on our judiciary as well as on the elected judicial process. Hopefully, we'll be able to provide you with some insight into the evaluation of judges, which might help you make educated choices on Election Day. With us today are two very special and important guests that might cast perfect light onto this important issue. Judge James Flannery is the presiding judge of the Law Division of the Circuit Court of Cook County. Judge Flannery was appointed as an associate judge in 1988 and elected as a full circuit judge in 1990. He's presided over 300 jury trials in the criminal division as well as in the law division. And then in 2014, Chief Judge Evans appointed Judge Flannery as the presiding judge of the law division. Judge Flannery is a former member of our Chicago Bar Association Board of Managers. Also joining us today is Scott Henry. He's the chair of the CBA's Judicial Evaluation Committee. Scott is a graduate of the Case Western Reserve University School of Law, and he's a partner in the Chicago law firm of Segal McCambridge. Much of Scott's practice is largely involving managing toxic tort, environmental, and other multi-district class action litigation matters. Scott's a former chair of the CBA's Young Lawyers Association, Young Lawyers section. Thank you both so much for joining us today on this obviously very important topic with the upcoming election on November 8th.
Thank you.
I'd like to start out by pointing out the fact that we have an elected judiciary here in Illinois. That's not the case in all states. Some states have appointed judicial systems. Other states have elected systems. There are pros and cons to both, and I'd like to get your perspective on that. And so, Judge Flannery, first, as an elected judge here in Illinois, what's your view on the elected judiciary versus an appointed judiciary?
Well, just as you said, there are pros and cons with either system. The elected system, the voters get to choose the judges. They elect the judges. And there's a lot to be said about that when the voters make the right decision. If you have an educated electorate, it's better, and they make informed decisions in electing judges. As far as the appointed system, some people call that the merit system, which is a good system depending on who's doing the appointments, who is making the appointment. We're all human, and there you can have good judges or bad judges as well. So there are pros and cons in each.
Scott, how about your perspective as a practicing lawyer?
Well, interestingly, as we were walking over here, I noticed in one Captivate, in that we all ride in elevators and we see quick little facts that pop up, and there's a statistic that 46% of Americans feel that elections are rigged. I don't know where that statistic came from, but it jumps out to me that one of the pros of an elected system is it empowers the people. It gives them a feeling they have a voice. One of my experience as a lawyer, and also my experience on the Judicial Evaluation Committee, is that the branch of government that people have the most contact with is the judiciary. People go into courts, whether it be for a traffic hearing or whether it be for a custody dispute. People are interacting with our government, and I see it as an attorney, through the court system. And so if they feel as if one of the benefits of the elected system is if they feel that contact with their government, they have a voice, I think that it gives them a sense of control and being.
Cook County happens to have the second largest unified court system in our entire country. The County of Los Angeles is a little bit bigger, but Cook County is the second largest in the country. We have 257 elected judges here in Cook County, more than 140 associate judges. Judge Flannery, can you please explain for us what the distinction is between an elected judge and an associate judge?
The elected judge, just as we were talking about, An elected judge is elected by the voters. In Cook County, and every county is a little bit different, as you said, every state is different, but in Cook County, judges can be elected what we call county-wide. So they run in the whole county, Cook County, like the state's attorney, like the president of the county board, but they're elected from the entire county. We also have in Cook County what's called sub-circuits. There are 15 sub-circuits, different geographical areas that are about the size of a senatorial district, where people can run, lawyers can run in those sub-circuits and be elected a judge. And when you're elected in a sub-circuit, you still have the full authority and jurisdiction that a judge does running countywide. An associate judge is a judge who's elected by the full circuit judges. And so the 140 associate judges you just mentioned, when there's an opening, a vacancy in the, for associate judge, people will put in their names, attorneys will put in their names, an application. The group, there's usually approximately 300 people who will run for anywhere from 5 to 10 to 15 vacancies. Chief Judge Timothy Evans will appoint a nominating committee who will winnow down those 300 down to twice the number of vacancies. So if there's 10 vacancies, you have 20 people running. And those 20 people will go, there's a 2-week campaign. They go and talk to the full circuit judges, and the full circuit judges vote.
Okay, so we should probably focus our attention on the 257 judges that are elected by the general public, because those are the folks that our viewers may have some influence in the ability to elect. Judges in Cook County don't run like the president does every 4 years for election. Judges are elected once, and then they go through a retention process. In fact, on this ballot, there are 35 elected positions that are open, and 58 judges' names appear on the ballot seeking retention. Can you explain that distinction for us?
Well, every full circuit judge runs for election once if you're elected. And so I ran back in 1990, I ran countywide, and I was fortunate enough to be elected by the voters. So you run once against opposition. After that, every 6 years, the full circuit judges run for retention. What that is basically, you run on your record, you do not have an opponent. The voters at the back of the ballot will vote either yes or no to retain Judge Flannery or whatever judge it may be. A judge needs 60% of the voters who vote in his election, his or her election, to be retained. And so you run every 6 years, you need 60% to be retained. If you're an appellate court judge in Cook County, if you're a Supreme Court justice in Cook County, you run every 10 years for retention. Okay.
I should point out right now, Judge Flannery, that you're an elected judge. You've been retained, I think, 3 times now. You're not on the ballot this year because it's not your turn to be up for retention again. But that being said, you're a sitting elected judge, and you cannot and will not involve yourself in any kind of politics with the judicial election. And so by being with us today, you're simply providing us with some background and some education, and you're not endorsing any candidates or criticizing any candidates. And I just think that should be made known.
That's correct. The canons of ethics provide that a judge cannot be involved in elections politics.
Scott, let me ask this of you. Obviously, with the presidential race, everybody's focusing on the November 8th election. But the sad fact is that if we follow any recent trends, almost half of the voters who actually go to the polling place and cast ballots skip the entire section on the ballot which covers judicial elections, okay? Why is that? I've heard people say to me, I don't know anything about judges, so why bother? Or other people have said there's too many names on there and I don't have time to spend all the time to do that. That's a shame, because that's not really taking advantage of what our process is here to do. You've got the CBA's Judicial Evaluation Committee. Tell us about the committee, tell us about the work that's done, and what your committee's work can do to help voters be more knowledgeable when they go to the polling place.
Well, I couldn't agree more that it's a shame, because once the decision was made to go with an elected judge process, that is predicated on the participation of educated voters. And so if the voters don't participate, then I think it weakens the system. The Chicago Bar Association believes that the quality of the administration of justice in our courts is determined in large part by the quality of the judges. So for the last, actually since 1887, is the first time the Chicago Bar Association weighed in on evaluating judges. So we have a long history of doing it, but for the last 30 years, we've had a comprehensive process, which, by the way, has in large part been adopted by the American Bar Association and numerous other local bar associations around the country. A comprehensive process where we evaluate judicial candidates, and that is done through their questionnaire, which I'll explain in a little bit, a questionnaire, then an investigation by volunteer attorneys in the Chicago area, and then a hearing where the candidates appear before our panel where questions are asked based on the investigation. We believe that judges should be evaluated on 8 criteria: integrity, legal knowledge, legal ability, professional experience, judicial temperament, diligence, punctuality, and health factors. And we believe that those 8 factors in totality, when evaluated, we can determine whether or not a judge is qualified, highly qualified, or not recommended to sit on the bench. And then it is our job and our belief that we need to educate the public on our findings to help them make the best decision possible.
Let me stop you there for a minute and talk about that education. But before that, I want to ask you about these different ratings that you come up with. The Judicial Evaluation Committee puts in what I'm sure are thousands of hours of work in coming up with these ratings. And then everything is sort of condensed into something that's called the Smart Voter Guide. And I have it here. It's a 2-page document which goes through all of the judges that are up for election or retention, and it tells the reader what the JEC's, the Judicial Evaluation Committee's rating is of that person. You mentioned 3 ratings for somebody that's running for a vacancy: highly qualified, qualified, or not recommended. Can you tell us briefly what the differences are between those 3 ratings?
Well, the clearly defined difference is that, as I had mentioned, there's a 3-part process to our evaluation of judicial candidates, and the 3rd part of that is the hearing. And at that hearing, there are typically 15 members, mostly lawyers. We do have some non-lawyers on the hearing committee that review the investigative report that is done by 2 different lawyers. And that investigative report is done based on the questionnaire filled out by either the sitting judge or the judicial candidate. And they have to list references, personal references, adversaries, trials, lots of information, lots of phone numbers. So to answer your very short question in a long way, the members of the hearing panel, those 15 attorneys, sit down, they interview the candidate, and then they vote. And that the most clearly defined way to distinguish highly qualified and qualified is if you receive a highly qualified rating by 80% of the people in that room, evaluating that judge based on literally dozens of hours of investigation into that judge, into publicly available material, into calling references, family, friends, adversaries, colleagues, bosses. If 80% find that person highly qualified, then they receive a highly qualified rating. If it's 60% of found qualified, then it's a qualified rating. Now, what's the distinction? It's almost, could be summed up, you know it when you see it, because there are just certain candidates that distinguish themselves throughout their careers from their peers, that they just deserve a highly qualified rating.
Okay. So the CBA's Judicial Evaluation Committee findings come out in the Vote Smart Guide, which can be downloaded for free from www.chicagobar.org. Anybody can have that, and you should get to it, and you should print it out and bring it into the polling place with you. But let's be clear, the CBA is not making any endorsements as to judges that are running against each other. Is that right?
Absolutely not. That is absolutely correct.
And if two candidates happen to both be rated qualified, then it's up to the voter to distinguish between those two based upon what other factors they may choose.
Correct.
Okay.
And when we do have the Vote Smart Guide is a very handy and what we hope useful guide, but we do also publish what is called the Green Guide that is more comprehensive, and it gives an explanation for a statement of reasons of why we find each candidate qualified. So that is also available on the website. And if you'd like to learn more about two judges that are competing in the same election, you can go there.
Okay. Again, referencing the Vote Smart Guide, which is the two-page handy document that somebody can walk into the polling place with, I'm looking at the recommendations for the 58 judges that are seeking retention to stay on the bench. And in that instance, the CBA is not saying qualified or not qualified. They're simply saying yes or no based upon the evaluation. And I presume that means the recommendation is either to vote yes or to vote no for retention. Is that right?
That is right, because even though we, in our evaluation, find them either qualified or not recommended, we want to make this as user-friendly as possible. When the voter steps into the voting booth, they will be pressing yes or no. So in our evaluation, it makes more sense, more intuitive to the voter to follow a yes or a no as opposed to our internal qualified or not recommended finding.
Judge Flannery, as we just mentioned before, you're not up for retention this year, but you have been through an election and through 3 separate retention elections. And I presume that in each of those instances you participated in the Chicago Bar's judicial evaluation process, right?
Yes, yes.
What's your perspective on the evaluation process, having been on the receiving end of it, for lack of a better term?
Well, my first impression, it is very, very thorough. The amount of time that the volunteers, the attorney volunteers, members of the CBA put into the process is unbelievable. The application, the evaluation application that Scott was talking about, I think is 20 pages long. It asks for all sorts of information. It takes the judges for retention and the applicants, or rather the candidates for election. It probably takes 40 hours to fill out the application. And as Scott said, it asks for all sorts of information, appeals, the number of cases you've disposed of, attorneys who have appeared in front of you, all sorts of things. And it's just very, very thorough.
Okay. Here's a fact that's rather disheartening, and I want to share it with both of you and get your perspectives here. As you mentioned, Judge Flannery, in order to be retained as a judge, you have to get a 60% yes vote in the election. Anybody receiving less than 60% yes is no longer a judge. When you look at voting trends after each election takes place, about 20% of all voters vote no for each and every judge that's on the retention ballot, regardless of his or her qualifications or experience or bar ratings. It's just a straight across the board no vote to everybody. Why do you think that is? I'll ask that to both of you. Scott?
I think it's just a reflection of voter disillusion regardless of what they are voting on. It's the throw the bums out type mentality that we struggle at the Chicago Bar Association of trying to figure out how to reach those people, give them the information they need, and say, hey, look, you may be dissatisfied with certain parts of your public service, but these judges, whom, by the way, we found to vote yes all through, and we think that that is something that they should take into consideration. They should know that just saying no to a judge isn't going to make their lives, if they're personally dissatisfied, any better. And education really is the cornerstone of the success of an electorate.
You made a comment there that you found every judge is up for retention recommended this time. That's unusual. 58 judges that are seeking retention, and the Bar Association evaluated all 58 and found that all 58 are recommended to be retained, right?
Correct.
And as far as I can tell, that's the first time in a couple of decades that has been the result?
And certainly in recent memory.
Okay. Judge Flannery, what's your perspective on the 20% across the board no vote?
You know, we live in a democracy. People are allowed to vote however they want. I have no idea why some people vote no and you know, why 20% of people vote no on all the judges. You would hope that we'd have an educated electorate and people would take the time to do some research. You know, for the judges, just as you would hope they do the same thing for every other office. But people have the right to vote how they want, and why they do that, I don't know if anybody knows.
No, and I don't, and back to a point that I made earlier, that the part of the government that people have the most interaction with is the court system. And so they really should, we encourage everyone to take the time to learn about the judges that they are voting on, because it could impact their lives.
Scott, you spend countless hours putting together the Vote Smart Guide. It's free to anybody who wants to download it. We encourage people to download it, give it to their family and neighbors and friends. How will the Vote Smart Guide help people when they go into the polling place and they see all these names that they've never seen before and they have to make educated choices?
Well, along with the Vote Smart Guide, if you are on the Chicago Bar's website and if you have the Green Guide, it details our very comprehensive investigative process. And that should give a level of comfort to those using it, that the amount of hours, the amount of impartiality, the amount of volunteerism that people are doing, are providing simply to make our judiciary better, should give them a level of comfort that our recommendations, or our findings, our findings, they can use to make their own decisions.
Judge Flannery, it's very rare that a presiding judge in the nation's second largest unified court system has an opportunity to speak to voters on the eve of an election like they are right now. And I'll take this opportunity to ask you what insight you might give to voters as they go into their polling place and cast their vote for the judges that appear on the ballot.
That it is very, very important that they cast an educated vote. As Scott said, it is much more likely that citizens are going to come in contact with the judicial system and with judges than with any other elected official, and that judges are going to have an impact on their lives. And so it's just very important that they should take it seriously.
I think that's all the time we have, and I want to thank you both, gentlemen, so much for being here and sharing your important perspectives with us on this upcoming judicial election. And thank you very much for paying attention and watching our program, Justice and Law Weekly. I hope you learn from this information and that you'll take the time to go to the polling place on November 8th and vote. And please vote the judicial election and do so in an educated way. We'll see you next time on Justice and Law Weekly.